Guru Nation, thank you so much for watching and listening. I really appreciate it. I've got my co-host Chris Sauber on
Hey
here
everyone.
and a very special guest making her first time appearance, but probably not last. Katie Anderson. She's one of our attorneys Chris and I use. We actually met her through some serendipitous roundabout way where we did not end up going after a building where our Yuma Clinical Trials is located, but we've gotten to know Katie, and she's actually helped a couple people in the industry already, and there's a lot of like transferable skill sets she brings from her law career into business formation and just watching out for your best interests, whether you're a consultant or a contractor or a site. And then Chris and I, we deal with a lot of clients and they always ask for different legal advice. Can I have my doctor do this? Or they're always asking crazy stuff. So Katie's LinkedIn is underneath. And hey, Darshan, please don't be mad at me, okay? Still got the comp. All right, Katie's gonna fly out to Philly one day and like meet you. We're still recommend Darshan. Darshan, the fraud pod's not going anywhere, but it's a big industry, and Katie has a really good skill set as well. And thank you for coming on, Katie.
Thanks for having me.
So, you've already looked at a few, like Chris and I do some advisory stuff. You're familiar with the research to some extent. Business is business, ultimately. What are some of from your career, biggest mistakes business owners make in like, let's start with company formation, because that's, I think, one where there's a lot of people watching that are site owners or want to start their sites or consultants. What have you noticed, like maybe top three mistakes they make, and maybe we'll double click on some of those.
Top three mistakes when people are setting up their business. I think often business owners don't think through the what if this all goes wrong. When you're excited, you're starting out, you're partnering with someone new, and you get a contract, and you're like, yeah, this is great because we're going to do all these great things. But they don't always think through, okay, but what if we decide tomorrow that we hate each other? How do we get out of this contract? How do we get out if
It
it's just that we hate
happens.
each other? Yeah, it
It
happens
happens. Chris and
often,
I ended up hating a few people after a while.
and
Remember?
you can't always tell. You can't always tell before you start.
No, this is
And
very
Ah,
true.
that's
yeah,
true.
and even more practically, what if you want to get out of it not because you hate the people, but because you're not making any money? You don't want to be tied to something that's a, you know,
A
loser.
time waste and no compensation.
Hold
Um,
on.
Exactly.
Can we go dark real quick? This is a left field, but like Chris may know where I'm going.
I already know you're not even gonna say anything, and I already know where you're going, but go on.
There's a strategy where if you want your principal investigator, so the doctor that works with you, if you're a site owner, to keep them on board long as possible. The risk is like you work with a doctor and then he or she decides they don't need you after they learn the business and they can do it on their own. Happens a lot. So by the
Yeah.
way, if you're like Katie's gonna help you like prepare for that. Um, one of the strategies is, hey doc, let's get after a year or two, like let's maybe go in on a building or something, where we're gonna operate out of. It's I call it golden handcuffs. I mean, other people have called it that, but it's basically golden handcuffs. Things tend to go wrong in those situations. I speak from experience, but what are your thoughts on this? Like, I told you it's gonna go dark a little bit, but then it'll get better.
Yeah.
But,
I mean, it's just
and I got a tangent to that question after you're done answering. I got one to
Ah,
follow
this
up
can
with
be
that.
3 hour podcast.
Yeah, I think it's just really important to really contract with all the expectations, everyone's expectations. Make sure not only that you talk about it and that everyone's discussed what they're doing and how it's going to look, but that you write it down. And if there's debt, everyone knows who's personally liable and who's not. And ideally, everyone has if you're going to have personal guarantees, you want everyone to be stuck with that, right? So I think it's really important to make sure that the agreement is in writing, read by all parties, and then that everyone has their own attorney looking at things because that makes it a lot easier. If you have someone who's yours and the other side is someone who's theirs, you don't need 137 attorneys, but it is good for each person to have a conversation with their own counsel who can explain to them, this is what you're agreeing to, this is what this is going to look like if this all goes bad.
Not the advice we generally give to our clients, but um,
Really?
yeah, and I'm not going to go into it here, but This question is something Dan and I field a lot. Basically, I'm going to make this a real simple summary. How do I make my PI a slave? No, we field this question all the time, do we not?
Yeah, and these are like not people you necessarily want to work with if you're a physician. We're sorry. You could probably do better, but yeah. And honestly, some physicians feel that way about the business owner equivalent of me or you, as well. So it's both ways.
So really what they're
Yeah.
asking is how do I get them to sign a non-compete, and is there more stringent contractual language I can put in place so where they just can't walk away, they can't go do other things, they're dedicated to me,
Right.
right? So,
Yeah.
and we always tell them, no, that's probably not even possible. And non-competes aren't really stringent, and there's not too many states that even have them at this point, is there?
Yeah, and they have to be really, really artfully drafted to be enforceable. A lot of times, really, the benefit of the non-compete is that no one wants to breach a contract, right? So
Mhm.
maybe it's not enforceable, but if I agreed to it, I'm probably going to abide by it.
Right.
But
It's more
I think,
it's more a scare tactic is what you're saying than
yeah,
effective.
I think so. They don't tend to be a fight. And who wants to litigate that? That can be so expensive, right? If you have to sue somebody because they breached the non-compete, and that's a lot of lawyer fees. I
What
mean,
do
it's
you
good for me
Sure. What
Yeah.
do you think that would cost?
for a breach of contract on a non-compete.
Yeah. To litigate that. Go to court and
Yeah,
litigate it through. Dan and I always tell them like 50 to 100,000.
yeah, to litigate through trial, probably. Yeah,
Yeah.
easily.
We're right on the money.
Yeah, you guys are you guys are right there. That's hard. Litigating non-competes is hard, but you can draft it so that it's not. So since it is really just instructional or advisory, you can draft it in such a way that the PI is not completely without options. Because if they decide they don't want to be there anymore, even though, you want them to want to be there, but if they
Mhm.
decide they don't want to be there anymore, they need to know what their life is going to look like. And if the non-compete's drafted in such a way that, okay, you can't be in this industry and you can't be in this area. So it has geographical restrictions and it has maybe certain types of maybe this type of study you can't work in or this type of, whatever this field, then I think you get a better, there's less likely to be like a blatant breach, and then you're not going to have to litigate it. But hopefully they'll still abide by those terms.
I I believe, and I could be mistaken, relatively recently, I think Congress passed, and I think it was signed. There's no longer, you can't legally have a non-compete in any state. I think I saw that. Does that sound
I don't
right?
know. It sounds there's something. I don't know if it was a federal law, but I know there was something really recently about non-competes and their
Yeah, I remember
enforceability. And
Biden was bragging about that, that he got rid of that.
Was it Biden?
Yeah,
Okay,
yeah.
so yeah,
yeah,
it's a federal. No more non-competes.
Well, so
okay.
related to this, because I know there's more frequently asked questions. Um, there's two, and maybe it's like a fallacy on my end, but there's two ways to partner with a physician to do a study if you're a research site. One is like, hey, well, there's three. There's W-2 employee, which nobody wants to do right away because there's no guaranteed money. There's independent contractor where it's like, hey, you're in my independent contractor doctor. I will pay you, X% of the budget that we get. Or making them an LLC partner. And if I find the right one, I usually lean towards number three because it's the most secure for me as a business owner, and they're not getting paid unless I get paid, so I don't need to worry about that. And they're more invested, at least in theory, in the long run. Now, if you go that route, LLC, right? Do you still need a contract with a doctor, or is the LLC and the operating agreement enough?
I think the operating agreement should be enough. You should be able to put that all
Ah,
together. Do you think so?
refreshing to hear.
Okay.
Most attorneys would be like, no, you need all of that, and I'll do it all for
And
you.
more? Oh, I
I
think, I
like
mean, I
that.
would put all that in the operating agreement. I would, if there's additional stuff, you can always say in the operating agreement, hey, we might need more contracts here because things may come up later that
Yeah.
that you don't think about in the beginning when you're putting everything together.
Yeah.
But if more stuff comes up, you can always have language in the operating agreement that says, "Hey, we can do this in a separate agreement. It will look like this."
Okay.
So
What about independent contractor agreement? I found a doctor, and this is how I usually get started with them. I found a doctor that's potential. He or she said yes. I'm not ready to make them LLC partner, and they're not either. But we agreed to work together for a year as an independent contractor. I'll be transparent. And it's just a like handshake, verbal, you got my word type of thing.
I don't know about handshake. You still want to have an independent contractor written agreement, right? And then you want to tie up
Okay,
all your intellectual property, and you want to make sure they're not, that you have the confidentiality agreement there.
I see.
And
So why not just that handshake? Like what's the issues with that?
I think you run into people, not everyone hears what everyone says, right? You might tell me something and I could hear something totally different. And it's not enforceable. So if your independent contractor without a contract comes in and works for you for 6 months and is like, I could do this, and leaves and takes all your information,
Hmm.
all your contacts and all your processes and everything, and
Yeah.
does their own thing across town, you don't
That's the
have any
risk.
way to
But what
recover
if I'm
that.
okay with that risk? Just handshake after, as soon as the meeting's over. Hey, dear doctor, this email's to summarize, like 3 sentences. Is that enough?
It would make me very uncomfortable. I mean, if you don't care, if there's no
I
risk in
wouldn't
it,
care. Here's why I don't
yeah,
care. If that doctor's new, within a year, he's not gonna learn enough to replace me. Maybe after like 3, but then it becomes, can they hire someone else to do it? Like that we kind of have the upper hand in that regard. It's more for their benefit. Like what I've noticed when I've done this, and I've done this most of the time until we do LLC, is it's implied that we will do a LLC if we like each other. And what I've noticed is for the most part, they're okay with it. And if they're not, then it kind of goes away. Like they still have to sign the research agreement with the sponsor if I get a study. So they still
mhm.
have a contract in place. I don't know. I don't like to overcomplicate things. I like to bootstrap when we're starting out, but I could be wrong. I'm just trying to get your opinion.
Yeah. I like to write everything down and have everybody sign it and have everybody on the same page, but that's probably
Okay.
my lawyer, my lawyerness coming out.
No, yeah, but there's a lot of people that would agree with you. I'm probably unusual in that regard. What about just Googling your state's independent contract template and just changing it a little bit? And
She's rolling her eyes at you.
I may or may not have done like all of these things at one point.
I think everyone has, right? Everyone's always trying to save, but honestly, like if you find just a smaller attorney, you're not going to spend it will cost you more in the long run if you use a Google
Okay,
document than if you just talk to somebody who has a little bit of knowledge.
To,
gotcha.
to to be fair to Katie, she didn't actually roll her eyes at you, but it was about the same thing.
Yeah, that's okay. I mean,
I
I
can't
probably
control
deserve
my
it.
face. All my words, all my thoughts just come across on my face.
It's probably warranted. Yeah, it's probably a lot of people when we tell them like how we got started, and even now, like with recently with the new clinic, every doctor's a LLC
Handshake.
partner now.
And
Yeah,
it's
all of
primarily
them.
a handshake.
Yeah, I don't spit in the hand, but
We
we do
should.
the
We should.
handshake.
That should be
Nah,
Blood,
after
requirement.
COVID, it's not
blood.
okay. I don't think.
Yeah.
It's not even okay to blow on a birthday candle. Did you know that? Like if you're at a party, like and they
Oh
sing happy
yeah.
birthday, they're supposed to go like this and not
Oh,
blow the candle.
please. Oh
I
my
was just at
goodness.
one where that happened.
Oh,
That's
please.
so weird.
So,
Okay,
just
so no Googling templates.
and an update on the non-compete. I put the language in the chat, but it went into effect September 4th. So just recently.
Yeah. Yeah,
Um,
and I wonder, I mean, this says between employers and workers, so I wonder how broad this is. Does it apply to independent contractors? Does it apply to joint venture agreements? Does it
Yeah.
apply? So I
Good
would,
question. That's where you need to be an
yeah.
attorney and figure that stuff out.
and that's a
Yeah.
good segue into because you also have worked with people in our industry already that are independent contractors, that are consultants. So not just sites, also just solopreneurs, right? People that
Mhm.
have a lot of knowledge and they're like, why do I want to keep working for someone when all these other people are asking me to do stuff? I have 5 projects right now. Let me call Katie and see what we can do. So what have you noticed there when it comes to like those kind of contracts? What are they typically not thinking about?
Consulting agreements. Yeah, I think it's important. One of the things that I've seen come up quite a bit is how do I get out of this? I think I said that earlier.
How do I
How do
get?
how do I get out of this if I need to? How do they get out of it? You know, if we start if we get going and we just really this is not going to work, you're not accepting my advice or you're not what do I need to do? And I think that needs to be really, really clear in your agreement. So for an independent contractor, if you're doing particularly in the consulting space, if you're, and the other thing that I've seen come up is when you have if you're consulting for multiple places, most of those agreements are going to have obviously confidentiality clauses, which of course, but there's also I've seen some pretty broad, um, all the intellectual property belongs to the company. Any intellectual property you develop belongs to the company, which is sometimes okay and sometimes way, way, way too broad. So you just need to pay attention and really look at those clauses and those agreements because you want to make sure that if you develop some kind of a process, yes, you were consulting with this one company, but you were consulting everywhere. And this is what I do. I help, trials get started. I help clinics learn how to do a better job. If that's what I do, my processes are my processes. They can't belong to the company and they can't be intellectual property of this one company, especially when I'm consulting with 5, 10, 15. So it's important to make those clauses can be refined so that it really only applies to things that really are property or make sense to be property of the company. But you don't want the knowledge of the consultant to somehow become the property of the company.
Right, right. We learned a
Yeah.
few things about fiduciary. And by the way, this is not legal advice. This is just Katie's opinion. But if you
Mhm.
want to get all of her, hit her up on LinkedIn. It's underneath this video or in the show notes. If you're listening, make sure you follow her. In that vein, so when it comes to these separating like what's yours versus what's your clients, is there anything that that the consultant can do? Like, would it be helpful if they had their own proof of their systems somewhere? Or like the more documentation you have, generally it's better for you, right? Should something go wrong.
Mhm.
Like what do you
Correct.
think they should be doing? Like if they know it's their idea, like how do they document that it's theirs? Like do they just write a memo to themselves or how does that work?
They can write a memo to themselves. The other thing I've been recommending recently to clients is to keep just a journal. This is what I'm doing today. This is where I'm at. And it doesn't have to be daily, maybe weekly on a project, but that are proprietary notes, not necessarily notes that belong to the company. And the other, I recently, there's a way to do it so that if it comes up where, hey, I created this thing, this might fall within this category. I don't think so, you can go to the company and you can include that in your original contract to just say, hey, if this comes up, this is how we're going to deal with it. If we think there's a dispute, this is what that'll look like later. And you can set that process of like negotiating or mediating something that could be a potential dispute. You can put that in your original contract.
And the issue with the reason you want to do that is I think it's something I just learned from you. It's not so that, because anyone can still sue anyone, from what I understand, but it's so that their attorney, if they take it to them, their attorney will pause and say, well, I wouldn't, because look what's in the agreement. Something like along
Exactly.
those lines, right?
Yeah, yeah, you want the other side to go. If the other person decides they want to sue you for whatever reason, you want their attorney to say, well, I'm not sure that they breached. This isn't super clear because there's all these other things that should have been handled here. You want
Let's let's say what incentive does the attorney have to say no? Like, I mean, we'll get into like some inside baseball here, but like, let's say I want to sue someone, right? I say, hey, Katie,
Mm.
look at my agreement. This bullshit. Like, let's go. What is your incentive to say, nah, Dan, that's not a good idea? Like, don't you just get paid anyways? Like, why would you care?
Yeah, I mean, I get paid hourly, right? So I love suing people. That's great. But I have
That's good business card. That's good business card.
do it. Let's do it. But I have an
I love to
obligation.
sue. That's perfect.
That's what I'll put on my coffee cup. Uh,
I like it.
no,
That's the
no,
next
I
one
mean,
coming up.
I hate to throw good money after bad. It's not, I mean, we have ethical obligations, obviously. It's our job to tell you, like, hey, you don't have a case here. Um,
Mm.
and we can get in trouble ourselves in addition to the client for bringing a case that doesn't exist. The attorney can get in trouble for bringing something that's not a good case. So,
Okay.
So I do have a
but
question. That's interesting. So let's say I'm a billionaire and this person who has limited resources has really pissed me off. So I want to get even.
mhm.
There's there has to be something there legally in order for them to bring a lawsuit.
There has to
Otherwise,
be,
you as an attorney can get in trouble.
yeah, there has to be a good faith basis for
Interesting.
the
Hmm.
lawsuit.
Did
And we
not
have
know
to,
that.
yeah, I have to do like an independent investigation, at least a little bit. I have to, at least a little bit. The standard's not super high, but I have to like look at the contract, make sure that I can reasonably decide that there's something to sue on here. And if there's really nothing, I'm going to tell you there's nothing. I can't bring this case for you because there's nothing here.
So that being said, though, I would have to assume 99%, maybe even more, of contracts has something you can sue over.
Yeah. Well, and that's why you want to have, so this has been my kind of my motto since the beginning of time. I started out doing business bankruptcies when I first started my career. And every time I'd be sitting there with this small business owner that had this mess, and it was always like, man, if you had just called me 4 years ago or called me 2 years ago and we would have done these things different, you know? And it's
Hmm.
always something different. You never know what it is. But that's why it's so important to get that original independent contractor agreement to really kind of work out these things in that original contract. Because when you get to the
Mm.
end and somebody has a lot of money and somebody doesn't, and there might be a lawsuit, you want to be able I mean, you can always end up in litigation anyway, but it's a lot better when you have, in my experience, when people draft their own contracts from Google from Google agreements, the litigation is a lot different than when they've
Well,
had an attorney draft it.
Okay. Well, Chris got a call, but okay, in that vein, so you've done, we're gonna go to bankruptcy because I have some questions about that. But with what you just said, one of the issues I've seen is that from our industry, with contractors especially, like there's a lot of CRAs out there, there's a lot of project managers that either got laid off but have a bunch of
hey,
experience
guys,
and
I'm sorry to interrupt, but I got to
yeah.
go. The attorney's calling me an hour early and
Another
says they need to
attorney.
do it
Okay.
now. So
No problem, Chris.
always
Okay.
a pleasure, Katie. Have a good
Yeah.
evening, both of you.
Thank you,
Okay. See you
Chris.
later,
Good luck
All
with
right.
Chris.
that.
Bye-bye.
So there's been a lot of like layoffs in our space, but these are like some of these people getting laid off are like very experienced and they want to go out on their own. And a lot of them don't have any choice but to go out on their own. But they're having no issues getting contract gigs where they used to have like other people are having issues getting hired as W-2, these people, because they're more experienced, they're actually, the market for contractors is pretty high right now, fractionalizing their spending. So if you have expertise, like they're even gonna pay you more, but just keep you at arm's length as a contractor. So there's actually a lot of people in this situation right now as we speak. They're just so happy. I've noticed this as an observer, and I know people in this situation. They're just happy as that they got a contract, they sign it, right? Like they might read
Mhm.
it. Okay, I'm good. But those contracts are so one-sided, like you just described. Uh, it doesn't hurt. Do you think it's in their best interest to like just have an attorney review it? Like,
Yeah, I do think it's in their best interest. Even if the attorney just says, "Hey, this is what you're agreeing to," just so that you may not push back because you're just happy to have the deal. That's okay. You know, you don't always have to push back, but sometimes like I'll have a client send me a contract, I'll send it back with comments and just say, "This is what this means. Are you sure that you're okay with this? What about this?" And just kind of raise the question, so that you really think it through. And there's ways to approach that. I know a lot of times people feel like, oh, I have a lawyer and the lawyer's gonna, I don't want to be adversarial, you know, because lawyers are adversarial
yeah,
by
yeah,
nature. But I think there's ways to be collaborative and to just say, hey, I'm gonna have my attorney look at it. That's just what we always do. That's what I
yeah,
always do.
yeah. It's in your SOP to just, plus it makes you look more professional to some extent. Like if you're a contractor, it's not uncommon to have that. I have a few questions about insurance and things like that, but bankruptcy. So I think there's lessons here for the site owners. Your career is basically like bankrupt. That's how I met you. There, I wasn't going through bankruptcy, by the way, guys, right? That's We were
That's
on the
what I
other
was waiting
side.
for.
We're trying to buy a building that could be taken out of context. What are like, I know you said every situation's different, but like you're always thinking to yourself, I wish you would have just called me 2 years earlier.
Mhm.
What are some of the common themes that those business people ignored that led them to get to where they have to contact you now?
Yeah. One of the things that people don't always think through is liens in personal property, intellectual property, insurance claims, things like that. So when you take out a loan and you lien up everything, right? You lien up your building, but you also lien up every other thing. So sometimes there'll be people just don't realize, oh, I didn't realize that something was collateral for the debt. And that's not, it's okay to give everything as collateral when you're taking out a loan and you need to, but you just need to be cognizant of it and know what you're doing so that you can work within that space. So you can work within the loan that you have. And then it's important to shop loans and not just take whatever you can get. You know, you got to look at, well, this lender is going to give me this. It's a higher interest rate. It's not as great. But you know what? I don't have to give a personal guarantee or I don't have to, you know, lean up all my personal property. So there's ways to, it's important to look at all those factors when you're on the borrower side.
Would you say that's like the biggest mistake they make is like on the side of like getting into too much debt and collateralizing everything? Or are there other things too?
Yeah. The other thing I see often is people get in trouble with taxes. It's really important to
Yeah.
make sure you keep your taxes in line, hire a professional for that stuff.
We saw that in
Um,
our case we were working on together. I
yeah.
was blown away. Um, what about fiduciary? I used to have a business partner that was an attorney,
Hmm.
and it wasn't voluntary. His mom was a nurse practitioner, and then she was like tired of doing the business, and I inherited her son, and I don't recommend it, but he always tried to scare me with fiduciary, fiduciary this. I think he was just trying to show off because he had a new law degree.
Yeah.
What about that? Like, because you're actually working as an attorney. Like, what is there something there?
I think that's common. New lawyers are always freaked out about their fiduciary obligations. I mean, it's always like that's the first thing in your head. And I get it. It's important. It's super important. I said that to a client just last week. I was like, wow, you have a fiduciary duty. So it just means that you're not acting in your own best interest, but you have to act in the best interest of the company. So, and that's kind of a hard balance when you're the owner and I only get paid if, you know, this and this and this happens. You have to, but okay, but what's best for the company? And then when that company, if that company were to be insolvent, the officers and directors have a duty then to the creditors of that company, a fiduciary duty to the creditors. So it changes a little bit when your company is doing well and everything's good. You have an obligation to do what's in the best interest of the company as an owner, as an officer, but you're going to do that, right? And the company's doing great. It gets a little sticky when the company's not doing so well and you're maybe heading towards insolvency and you know you're having a hard time paying your bills, you're deciding what to pay. If you take a big draw to pay yourself but you're not paying your creditors, then you can expose yourself to liability from the creditors of the company, even if you don't have a personal guarantee.
Okay. Now, back to the shifting back to the research site owners, the clinic owners, the physicians. Our physicians all have malpractice, and in research, you use the doctor's malpractice, like it's in the contracts when that you sign with the drug companies. But a lot of sites carry their own insurance, and we have like premise liability.
Mhm.
Um, what else do you think a clinic might need? Like, do you think errors and omissions? I get asked this question a lot too, and I never have a good answer.
Yeah, I don't know, Eric. Well, you definitely want to have a policy that'll cover your officers and directors in the event you get sued for a breach of fiduciary duty.
What is that kind of
Um,
insurance called? That
D&O insurance.
DNO. Okay.
Yeah,
I'm
directors and
gonna write
officers.
this
Yeah.
down.
So your D&O insurance is good to carry, just to make sure the as the owners you're not getting if you get sued, you
DNO
have
insurance. Okay.
yeah, premise liability in case somebody falls, right?
Yeah.
Or dies. The malpractice makes sense. What other, I mean, the way to look at what insurance you need is what are the potential risks? What could happen, right? What's a terrible day, your worst day at work? What's the most terrible thing that happens, you know?
Like a patient gets injured, and this hasn't happened to me, but a patient gets injured, they blame it on the study drug, You already have that covered in your contract with the sponsor, as long as you're complying with good clinical practice and the protocol and you're not operating outside of the protocol, which you're not supposed to do, the sponsor will pay for it. But if the sponsor then says, and they would have terrible reputation if they ever did this, from what I've been told by many people in the industry in the know. If like let's say a Pfizer threw one of their investigators under the bus. No, we're not gonna pay this, that's on you. That reputation gets out, no one's doing studies with them ultimately. So they don't do that. They tend to protect the doctors. But
Mhm.
I don't know, just something like that. Like if a patient gets injured or tries to sue you directly, or um regulator comes in and says, "Hey, you guys are like this is severe misconduct. We have fines for you guys, and the drug company is not protecting you in that case." So that kind of stuff.
Yeah, you got it. Well, I think really you hit on this. You really just have to make sure you know what's in the contracts and you comply with it, right? So you know
Yeah.
what's in your agreement with your sponsors and you're doing that stuff. And then you know what, take a look at your insurance policy. Yeah, I looked at mine the other day and I was like, my limits are way low. I need to fix this.
Mm.
And it was just on my car insurance, right? So take a look at that and think about, okay, I saw this award. So potentially we could have this much exposure because if your policy limit is $25,000 for bodily injury and someone, dies, that's more than 25,000. So
Yeah.
it's important. You want to carry enough to cover the potential risk too.
Yeah, those are like there's some of the big risks, and then which they've never happened. I've been doing this 20 years, but you got to operate carefully when you do this kind of stuff. But also like getting sued maybe from a drug company. Maybe they monitor your site and, hey, your data's terrible. We're not paying for this. We're gonna sue you. Like that kind of stuff is also like would be on the spectrum of a very bad day.
Yeah. And I don't know if there's insurance that would cover something like that. I mean, that's just a breach of
Ah,
contract, right?
okay.
Yeah.
That wouldn't be errors and omissions.
It might be. I don't know. I'd have to look at it. I just don't know the answer to that one.
Yeah, because we don't have E&O, but I know there's like umbrella. When people say umbrella policy, is that premise liability or is that something else?
Usually an umbrella policy covers what you don't have coverage for. But I think
Uh,
with insurance agreements, you really have to like read through them and make sure you understand what you have coverage for.
yeah.
Because the insurance company's gonna be the first one to say, nope, 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 not us, not us.
But the DNO one's that one I'm gonna get because I think that's the one of my business partners was actually asking about. He's you know him from the our interactions with the previous building. Um, Shout out to Jaime, but he's always worried, and he's not even the PI, he's the sub-I, but he's always worried, because he is a nurse practitioner and his license is on the line. So I think the DNO, because he is a director and an operator, would be.
Mhm.
I think that's exactly what he was asking me about.
Yeah,
So we'll get one of those tomorrow.
yeah. Talk to your
Okay.
broker. Yeah.
All right. Now, what about like if you're a consultant marketing yourself? Let's say you've worked, every contract has like these non-disclosure. How much are you actually allowed to talk about at your next job? Like, or in the interviews, for example. Like, hey, I see on here you worked for, Pfizer. Let's just go with them
Mhm.
again. Can you tell me something about what you did there? Like, when are you crossing the line, in your opinion? Again, not legal advice. Contact Katie for your particular situation, but just your thoughts on this.
Yeah. It's going to depend on what your contract says. And it's going to
Your
depend
initial
on that
contract.
your contract that, yeah, your contract with the company with respect to that, because it's going
Okay.
to depend on the definition of confidential information. What's confidential in the context of that contract? And that varies from, contract to contract. And that's the other thing that if you can push back when you're entering into that to limit that. Obviously, some things are just have to be confidential, but you want to be able to push back and say, okay, well, my processes are not, and I can talk about this and kind of define that in that original contract.
Okay. Another question I get asked a lot that I never pretend to answer is about employment. So if you're a research site owner, you're supposed to have W-2 employees. I know there's ways you can have contractors. People ask me, well, what do you prefer? my coordinator, I don't want to take a risk, W-2, pay all this all this workers' comp and all this, which is actually not that
Mhm.
expensive, guys. I looked at our payroll and it's like negligible cost for what these budgets are. But people always want to know, hey, should I hire my coordinator as an independent contractor or hire them as a W-2? And I always tell them consult with an attorney, but and every state's different. But what are your experiences or thoughts on this issue?
Yeah, I think it's going to depend on every situation. It's going to depend on your tax, the tax situation for that particular entity. Um, how, yeah, and what it looks like. How many employees do you have? Because that is something that's like scale. If you just have one person, then probably independent contractor makes more sense. But maybe not. Maybe it makes sense to do it, you know, through uh through a W-2 agreement. It just depends. So
Yeah.
I think it's just going to be everything's different, and it's going to depend on the personal facts of that case.
And I know with W-2 versus 1099 employees, like technically, and maybe I'm wrong on this, but with a 1099 employee, first of all, it's a wrong terminology because they're not your employee. But with a 1099 worker, you can't tell them what time they could come in, when they could leave, or can you? I mean, I don't understand that. And then there's also the salary versus hourly thing too.
Yeah. 1099, you don't have to withhold taxes. You can just uh,
Yes.
pay them the full amount, and then they have the obligation to pay taxes for that. And you report to the IRS how much you paid them on a 1099. I don't know. I'm not an employment lawyer, but I have some friends. If you need a referral, call me. But I know that the employment rules vary from state to state. There's federal, there's local, there's state rules. And so I don't know if you could tell them when they can come in and not. I mean, it seems like you would be able to just come to an agreement on with anybody on anything, right? But
Yeah. And
but
I
who
come
knows?
from the strictest state. I'm in Arizona now, but I come from California, and over there it's like almost illegal to have a 1099 worker for like almost any reason. So I erred on the side of caution all the time. When I moved to Yuma, we did have 1099 staff for a while until we just we were confident enough to have a payroll, and now we have it. It's just simpler that way.
Yeah.
Are you allowed to pay, from what you know, pay someone, if you have a W-2 employee, are you allowed to issue them like a 1099 as well at the end of the year if you paid them both ways?
I don't know. Maybe you could do like a partial. I mean, if they were 1099 and then you converted them to W-2, then you would probably issue both for those time periods.
Yeah,
But I don't know if you
yeah,
could do both at the same time.
for the same company, right?
Yeah, for the same, I mean, would it be
Because
okay,
sometimes
these
it's
things
easier to
are
like reimburse someone through just
mhm.
writing a check versus going it through the payroll.
Yeah, those are all I would say CPA questions.
Yeah,
Like
these are
that's
crazy. I gotta introduce you to my CPA too, which is
yeah.
pretty cool. A last thing, because I know you've got to go. And by the way, everybody go connect right now with Katie if you're watching or listening. There's a lot of like in our industry, there's a lot of like regulations around patient protected health information. This is what Darshan is like expert on, and every time I have him on, it's impossible that any research site or even any drug company is compliant. So no one's compliant, guys. I don't care how goody two shoe you think you are. Um, my final question for you would be having an attorney on retainer. Like, how do you guys actually charge? Because a lot of people are afraid, especially when they're starting a new business, like, oh, I'm a little bit worried about committing to that versus like a retainer versus just paying for the service. Like what is the pros and cons of both?
With how you retain counsel.
Yeah.
Yeah, I mean, there's so many. Every attorneys can do whatever they want, right? So, I mean, not whatever they want within the confines of our ethical rules, but attorneys can sometimes be very flexible. I've had clients where I'm on retainer where they pay me X number of dollars a month and they can call me for little stuff, as much or as little as they want. And then if there's a particular matter, then I would take that like on an hourly rate.
Mhm.
Um, I've had clients that I take everything on an hourly rate, and I have a um, a retainer. They pay, the retainer, and then I deduct from that on an hourly rate. We've done that before. And then sometimes, depending on the case, attorneys will take things on contingency for different kinds of matters. I try and stay away from that.
Yeah, like Chris
That's
was
not what I do.
asking. That's who Chris is on
Yeah.
the phone with right now. Somebody's on
Yeah.
somebody on
Contingency.
contingency. Well, I gotta say, my favorite bill I receive from you is when they say $0. So thank you for
Yeah.
those,
Those are the
Katie.
best ones.
Those are the
Yeah.
best. We appreciate it. Look, everybody go connect with Katie right now. Her LinkedIn's underneath. Your LinkedIn's been getting active.
I
You
know.
you you, th you
It's
should start a newsletter.
yeah, I should. I'm gonna take some Dan advice and get
Yeah,
on
there's a
that.
lot of demand for that. LinkedIn algorithms pushing the newsletters like crazy,
Yeah.
disproportionate. So everybody go connect. I've worked with Katie now for half a year, maybe a little
Yeah.
less. But
Yeah.
it's been on
Not
a
too long.
couple projects and only adding more. Thank you so much, Katie. When people can
Thank
reach
you.
you, you have a website ready or just your LinkedIn for now?
I have a website, cochraneandersonlaw.com.
All right, we'll have that underneath as well. Thank you
Thanks.
everybody for watching, listening. Go connect. Bye bye. Thank you, Katie.